Well, welcome everyone to the latest edition of the Slingshot. Today we have a special guest, Randy Stutz from the American Antitrust Institute. He is the president now, new president at AI. Now, prior to that, Randy did a stint at the FTC as an attorney advisor for 1 year. And he was vice president of legal advocacy for AI for 14 years before that. Before that, he practiced antitrust at Skadden Arps for about 3 years. Randy holds a JD from the Catholic University's Columbus School of Law. If I could just go on about Randy, he's written a ton of articles, journal articles on the subject of antitrust. And he was the associate editor, co-editor, of the Private Enforcement of Antitrust Law in the United States, Edward Elgar Press 2012. So honored to have him on the show. Welcome, Randy. Thanks for coming on.
Thanks, Al. Great to be with you. Thanks for inviting me.
Yeah. We have so much to talk about, but I feel the news today, the headlines today, just reading that deal book, is being dominated by settlements in major class action cases. I think today's news was dominated by the MasterCard Visa settlement. Prior to that, it was the real estate settlement. And then I think another case I may have heard of called the UFC settlement. It just seems to be dominating. Is something weird going on? Do we feel the ground shifting afoot, or am I making too much of this?
It could be the ground shifting under our feet. It could be just some strong cases, with some really excellent expert witnesses, perhaps, for example, in the UFC case. But these are great developments. These are cases that a lot of private actions end in settlement, and that's usually an indication that they're meritorious, because otherwise they get fought quite vigorously. So I think these are some strong cases, but I also think we've seen a lot of victories, but public and private. There's been a spate of them, so it's worth watching.
Yeah, and we didn't get a chance to say hi to Darren yet because I got so excited about these settlements. Darren Bush is joining us, and he's going to be helping me and questioning Randy, grilling Randy with these questions. Hey, Darren, how's everything? How you feeling?
Life is going well, and I'm glad we're able to say your name with respect to being an expert. I know some publication didn't do that, so.
Oh, well, I think this is going to become my new Twitter handle. I'm going to forever be known as an economist. An economist, yes, an economist in the case.
One economist. You're one economist.
So. Oh, one economist in the case. Yes, I was one. I'm going to give a shout out actually to Alan Manning, and Andy Zimbalist, who were also in the case. And played important role. While we're giving shout outs, I just want to say real estate was Einar Elhage and Nick Economides. Visa MasterCard was Stiglitz and Leffler. Just, why not give them a shout out? No one's probably ever going to say their name out loud. We might as well do it on this damn show. Anyway, today we're going to talk about 3 different topics, not the settlements. We wanted to talk about the DOJ's new suit against Apple. We want to talk about Randy's new law review titled law review article titled Choosing Between Two Meanings of Competition and Antitrust Law. And then the third and final topic to wrap things up will be the future of the American Antitrust Institute. So Randy, let's start with the DOJ suit. I was hoping that someone could write a piece for me, but Matt Stoller just is always writing like the day after the news breaks. And I imagine you probably saw his blog. But he had an interesting stat in there that spoke to the ability of Apple to retain its existing customers. He threw out a stat of 98% of iPhone owners buy a new iPhone, which sounds a lot like my family, which is around 100%. And whereas in China, he said that number, at least a few years ago, was only 50%. And Matt reasons that in the US, it's difficult to move out of the Apple ecosystem, in part, he doesn't say entirely, but in part because in China there are these things called super apps like WeChat and Alipay, which I guess moves things away from the Apple ecosystem, moves it to, I guess, the equivalent of what middleware was in the Microsoft case. But I want to know, what do you make of that stat, the 98 versus 50%? Do you think that it suggests that Apple has some stranglehold or some stickiness or super lock-in of its customers in the US, or does that just reflect really strong preferences towards Apple? And does it even matter for assessing the DOJ's case?
Yeah, well, first, let's pause for a second and just appreciate the fact that we have another major monopolization case we get to chew on here. You know, we went through such a drought for I think 2 decades without any of these, and now we've got another great one. I think it's a really strong case. I think the government should win, and it's a great, well-drafted complaint, 88-page complaint. There's a lot that jumps out, but yeah, I mean that is a crazy statistic about retention rates in the United States versus China, where super apps are sort of available and not suppressed. And you know, I think it just begs the broader question about, you know, how can you have such different market dynamics and such different retention rates and different behavior? You know, how can Apple explain that? I just think it sort of commands some kind of explanation as to, you know, what's going on there. Obviously you've got different behavior, different set of restrictions, and drastically different market share in terms of retention. So it's sort of, I think it puts the onus on Apple to offer some kind of explanation.
Yeah, you wrote a piece, Randy, in I think May of 2022 about Apple, called "Protection or Pretext: Structuring an Appropriate Antitrust Analysis of Apple's Security Justifications for App Store Restrictions." And the DOJ complaint, you know, kind of addresses this. It says Apple would meet competitive threats, I'm quoting here, by imposing a series of shape-shifting rules and restrictions in its App Store guidelines and developer agreements that would allow Apple to extract higher fees, thwart innovation, offer a less secure, degraded user experience, and throttle competitive alternatives. It has deployed this playbook across many technologies, products, and services, including super apps, text messaging, smartwatches, digital wallets, and many others. That sounds really familiar. You know, Tal mentioned Microsoft before, and you know, recall, Microsoft doing some similar things about interoperability with Java and things of that sort. How much is the Apple complaint kind of mirroring Microsoft?
Yeah, I mean, I think it clearly, the complaint sort of sets up, I think it's teed up nicely for a judge to kind of use Microsoft as a handrail as it sort of walks its way through the case. You know, it's the same broader theme that you see about sort of preventing disintermediation and strategies to sort of, you know, prevent switching, raise barriers to switching. You know, the government mentions the sort of shape-shifting rules in the DPLA and in some of the other app distribution guidelines. You know, again, it's sort of like we've got this natural experiment in China that Hal mentioned, where we actually have, you know, super apps are not suppressed there, and we see drastically different performance indicators in the market. You know, Apple's going to have to come forward and explain why that's just correlation and not causation. And I think, you know, you see, I think that's going to be hard for Apple to do, or at least hard to do without shooting itself in the foot on market definition. You know, this was in the Epic case. Apple argued for a global smartphone market where it had something like 15 to 20% market share. You know, again, it's sort of, we've got these, if we're saying that these, you know, you've got different sets of rules and restrictions in different geographic regions around the country and different market shares and performance indicators that sync up with those differences, it's sort of, it makes it hard to maintain that this is a single global market. You know, the pro-competitive justifications are also interesting here, you know, and again, you know, Microsoft is relevant, but I think you can look at just the Epic case, I think, for some really close comparisons. But you know, the piece I wrote about Apple's security and privacy justifications was written before the appellate court decision in the Ninth Circuit. But I thought at the time, and still think, that the court really botched the analysis of pro-competitive justifications, and specifically the analysis of pretext, which, you know, I think there's an important issue that will factor into this litigation, and that is generally important in all monopolization litigation where pro-competitive justifications are offered, that just who has the burden of proof to establish pretext. And I think in Epic, both the district court and the Court of Appeals really sort of took for granted that it was a plaintiff's burden to establish that Apple's security and privacy justifications were pretextual. And I don't think that's quite right. What was interesting is that in Epic, you had this notarization model that was held up for comparison, which is in the Mac ecosystem. There are not the same kinds of restrictions on app distribution that you have in the iOS ecosystem. There is not the same human review, and there are not the same limitations on, side loading, for example, from other app stores. There's just a warning, you may be at greater risk of malware if you don't get your apps from Apple, if you use a third party. And the court in Epic it didn't accept that, didn't buy that. It saw some meaningful distinctions between the iOS ecosystem and the Mac ecosystem, wasn't willing to find pretext on the basis of sort of Apple being, willing to let go of those same restrictions and for a different product with a different ecosystem that's otherwise very comparable. What's interesting here in this case is, again, we can look at other geographic regions where we're talking about the same product, right? This time it's an apples to apples comparison. We can talk about iOS. Yeah, right? Their super apps are happening in China. They're not happening in the US. So, it's sort of, again, I think it just behooves Apple to come up with some good explanation for why these justifications are necessary.
But the security discussions, I mean, they become more prevalent in any of these in interoperability type platforms such as Apple products and Microsoft. I think Microsoft made some arguments about security too at some point. But it goes back further than that. I remember when we were doing competition in electricity markets, and there's the discussion of, well, if we could interconnect with non-utility competitors, that could mess up the grid and transmission and all of that. So it's really a classic strategy. I guess we could say the apple didn't fall far from the excuse tree.
Yeah, I think we could say that. And, again, it's sort of like I keep coming back to the sort of different experiences that you see in Europe and Asia. And then, okay, like maybe there's some facially plausible explanations for security rationales that could be sort of linked to some or many of these restrictions. But consumer demand, we're seeing consumer demand in other geographic regions for a loosening of these restrictions. And so, I think you're arguing from a place that, it harms consumers to respond to consumer demand. And that just seems like a bad place to be arguing from. Again, it's not necessarily, there's a lot of fact issues and fact questions, and a lot of this stuff is, discovery is going to reveal a lot. I'm not saying at all that this is a slam dunk case, but I think it's a strong case because it just sort of, it begs some of these obvious questions. Sure.
Some folks on Twitter, who I affectionately refer to as pro-monopolist, might beg to differ with you on that, Randy. There's a lot of mocking of the complaint, particularly on the aspect of degrading one's quality as part of the anti-competitive scheme. And in particular, what I saw, they said that this critique, of course, in my opinion, naively presumes that quality degradations will swiftly be disciplined by defecting customers. But of course, the costs of defections are small in the face of large switching costs, some of which are artificially heightened by Apple's scheme. And if the benefits from impairing one's rivals are large, then there isn't any profit sacrifice needed at all. My question for you, and I don't know if you had a chance to see any of these tweets, I'm happy to, I think I may have shared some with you. What do you think of this concept is so hard for certain folks? including antitrust law professors, to understand.
Yeah, I'm with you on this. I mean, to me, like you're the economist, but the math here seems pretty simple. You know, the value proposition from preventing disintermediation exceeds the costs of equality degradation. Aren't you going to opt for the former 100% of the time? It just and then the other sort of, I think the obvious rejoinder to some of those kinds of criticisms, and again, I'm not referring to anything specific, but just sort of directionally, you know, the idea that it's a spatially simplistic and understandable idea that no firm has an interest in degrading the quality of its own product. But again, there could be severe risks to the business model if Apple allows disintermediation. So it might view this as a defensive measure. And then you have to factor in that we're talking about a network market and a network environment, and that the switching costs are enormous because, you know, if Apple or any platform for that matter chooses to degrade one aspect of the experience in an entire broader ecosystem, for a user or a developer for that matter to switch to a different ecosystem, the value proposition has to be such that it's worth switching everything. You know, all the different benefits that come with being plugged into the network together have to be less than the cost of accepting the harm caused by the quality degradation. And so there, you know, I think it's clear, it should be obvious that there's always going to be some room for a firm with market power to impose some quality degradations when it's in its interest to do so. And to me, again, that this is just more evidence that Apple has market power, right? I mean, the fact that it would not respond to consumer demand, that it would choose to do this, is evidence that it can afford to do this, that it can accept that risk without losing too many sales to rivals. So
Randy, so why would a consumer, so suppose I feel I sense some quality degradation. That may not be the consumer may not be outraged enough to even consider switching, first of all. Secondly, why would the consumer assume that the quality degradation is solely one platform, such that if they switch to the other platform, they would suddenly have a superior app? Won't most consumers think it's the same app regardless? And if that's the case, then there is no cost to decreasing quality, because the consumer is going to go, it's just like that everywhere else, right? It's the same Arby's, it's just in a different location, and it's going to be the same food.
yeah, completely agree with the point. And I'll make a slightly different but related point. And I'll give you an anecdote, which involves my 80-year-old mother, who has said to me, you know, why would anybody use one of those Android phones? Those green texts, they're so annoying. My mom's an iPhone user. I think she had no idea that she thought it was Android's fault that their texts are inferior when they appear in the iPhone ecosystem. So, you know, there's all kinds of, you know, if there's an information failure, other kinds of, there's a long literature on you know, sort of consumer protection market failures, you know, information failures that give market power to firms that even have small market shares, because consumers don't have the sort of requisite information necessary to hold the right party accountable even. So it's a great point.
All right. Well, I think that we could talk about Apple all day, but we got 3 topics to knock out today. So why don't we move to topic number 2? And I want to now talk about Randy's new article, which I read and was really good. I highly commend folks give it a try. But let me just try to set the table a bit, Randy, with these terms at the beginning of the piece, because it might be hard for folks to understand. I had to get into the middle of the piece to fully understand it. But you're right. The Supreme Court has, quote, never clarified whether competition fundamentally is a behavioral or a static concept. So I was hoping you could just define for us what you mean by behavioral and what you mean by static. Why is that distinction important? And which interpretation would give more employment to expert economists? I'm asking for a friend.
Well, yeah, we're switching to the point of the conversation where things get more academic and abstract, which is fun. First of all, Hal, I wanted just to assuage any concerns, right out of the gate. I think it's impossible to do any antitrust without economics. So I think the guild is safe regardless of which definition you choose. To me, it's more a question of whether economic logic and economic reasoning are meant to serve as sort of a wholesale substitute for policy making and legal decision making, or if it's more of a complement and sort of a useful tool for lawmakers and policymakers to employ while they're exercising agency and making conscious choices rather than.
I appreciate that, and I don't mind if you guys get rid of economics. I just would ask you to wait for maybe eight odd years. My oldest is starting medical school soon, so just give me a couple of years where you excise it entirely. But sorry, go ahead.
I'll try to stagger advocacy along the lines of your kids' career paths. No, but just to sort of back up, the meaning of competition and antitrust law is I think competition is a word that most people just assume they understand, and that a lot of times people use the term without appreciating the possibility that other people may not share their exact understanding of the term. And it has this sort of ambiguity, but it's a pernicious ambiguity. It's an ambiguity that's not always recognized, and that people sometimes don't even appreciate at all. I got interested in this topic, the meaning of competition, from reading a lot of antitrust cases over the years, where it was clear that judges often use this word in very different ways, and I think loaded up with very different meanings. And really, my interest in writing about it came about. It was in a lot of ways, it was inspired by some of the work of Professor Land, Bob Land, one of the greatest living progressive antitrust scholars, who's done a lot of work in a lot of different areas, but lately has written quite a bit on textualism, sort of Antonin Scalia style textualism as a method of statutory interpretation applied to the antitrust laws. And one of the interesting things, the word competition does not appear directly in the Sherman Act. It actually was in the original version of the bill, but it changed and got amended in committee, and the version that passed prohibited restraints of trade and monopolization. But of course, the Clayton Act and the Federal Trade Commission Act use the word competition, and they use it directly in the liability provisions of the statutes. And so it's a statutory term that should be subject to rules of statutory interpretation, including rules that require ambiguity in statutory text must be resolved. And so this is what, Bob Land is retiring from the University of Baltimore from teaching, and the Law Review is doing a Festschrift edition in honor of him, where a number of antitrust progressives are making contributions. And so I felt like I sort of had to write this article for Bob, and it's just something I've been wanting to do for a while. So very long-winded intro. Let me get back to your actual question, which was the difference between static and behavioral conceptions of competition. Really, this is, I know another way to think of this is just the difference between the layman's definition of competition and the economist's definition of competition, or whether we define competition as the beginning or the end of the competitive process. Whether competition is a type of behavior, a catalyst that starts the competitive process, or whether it's a type of outcome, an equilibrium outcome in a market with that's characterized by some change in a prior equilibrium. Usually with competition, we associate it with lower prices, higher output, things like that. So that's really the distinction I'm talking about. And when we think about, for example, in the Clayton Act, of mergers that may substantially lessen competition, I think we have to ask ourselves, is our concern that the merger will lessen a type of behavior, or that it will lessen a type of outcome, that the harm is something that we measure by outcomes, or do we look to the behavior itself? So that's sort of the fundamental difference that I'm talking about. And you can look at it through the lens of the competitive process and as a beginning or an end.
So let me push you a little bit about this, because it seems to me I was gonna try to be nice, but I'm just gonna be my usual blunt and jovial self. It seems to me like it's a false dichotomy, and so when you have sort of the rules of a game, yeah, that what the competitive process is the rules of the game, and that requires some sort of structure. We used to have this old structure, conduct, performance paradigm, um, and so the sort of the structure of the market determines that there could be multiple competitive outcomes, right? And so I don't think that it necessarily means that there's not winners or losers. But at the end of that result, there's this competitive process. Um, and one thing we don't talk about with respect to that notion of competition, I'm just babbling for a second, but there's a point to this, is what happens if it doesn't turn out that the end of that process is competition? We used to talk about regulation and things of that sort, but we don't anymore. So, so if you're talking about sort of structurally unbundling this structure, conduct, performance paradigm, Randy, I'm not sure I'm on board. Uh, and also, I think if you're looking for some end goal, we have to come back and bring in some of that regulatory structure into the process as well, because it doesn't always end with a happy competitive ending.
So these are all excellent points, of course. And I'm gonna respond, but I'm also partly gonna dodge them.
Okay, that's fair.
But let me explain why I'm gonna dodge them. First of all, when we're attempting to look at statutory language, so I'm doing a legal exercise here. This is not an exercise in sort of choosing the appropriate economic paradigm as between structure, conduct, performance, and Chicago welfare analysis. This is also not an exercise in choosing goals. This is not this paper, I think, belongs alongside the debate over whether consumer welfare is the best goal, or a more diverse set of goals is proper for antitrust law. This paper looks at how Congress conceived of competition when it created our foundational antitrust laws, the Sherman Act in 1890 and the Clayton Act and FTC Act in 1914. And a lot of their views, I think, are a product of just how undeveloped economic thinking was back then. Most notably, I think that just the entire concept, the entire idea of a static conception of competition, the idea that we would think of competition not as a type of behavior, but as a state of affairs, as an equilibrium outcome. That idea didn't really exist at all in economics when the antitrust laws were passed, right? And this is what textualists do. We look back to contemporary meaning when the statutes were passed. And so it's completely implausible that Congress had a static conception of competition in mind when it passed the antitrust laws, when it used that word competition in the Clayton and FTC Acts. It really couldn't have had a static conception of competition in mind, because the concept, the original theory of perfect competition, which is what all static conception of competition are sort of based upon, didn't fully exist yet. It was in its infancy. It was being discussed, but it was not. Most scholars, place it sort of after the First World War, 1920s, 1930s, around then. And so, one thing that's really conspicuously absent from my paper is any discussion of structure. And of course, market structure is very important in an antitrust analysis. The case law has made that clear over many, many years. But I think, if we're going to try to do the exercise of interpreting what Congress meant when it prevented conduct that hampers competition, it was talking about behavior. It was talking about firms struggling against one another in a way that has positive tendencies. That was the language of tendency rather than of outcomes was everywhere, both in early case law and in early economic thinking around that time. This was the idea that we could sort of trust in competition to deliver benefits, even though they're not guaranteed, right? And this is another theme that you see in a lot of early case law, including Supreme Court case law. It's the idea that competition can be bad. Competition can lead to terrible results. And nowadays we don't usually accept that. We tend to say if it leads to bad results, it's not competition, right? So like there's a wonderful example. Jonathan Baker has a paper where he found a news story where a pizza chain owner went down the street and committed arson and burned down a rival pizza chain. The idea being that all the customers would have no choice and would have to come to its pizza restaurant since its only rival was in ashes around the corner. And I think 100 years ago, that would have been considered competition. It's not socially desirable. It is not socially beneficial. It does not create efficiencies. But it was behavior designed to increase demand for a product. So competition is not always good under a behavioral conception of competition. The idea is that it has, on the whole, in general, positive tendencies. And I think it's up to us under this view to sort of distinguish between reasonable and unreasonable forms of competition.
Randy, let me ask this just to really make it easy for our listeners who are trying to separate the two concepts in our head of behavioral and static. Why don't you give me a fact pattern? I realize this is just kind of out of nowhere. Why don't you give me a fact pattern that would be condemned under a behavioral approach, but would be tolerated or condoned or escape scrutiny under what you're calling the static or outcome-driven approach?
Yeah, so this is really important. How you choose to define the meaning of competition, whether you define it as a type of behavior or a type of outcome, does not dictate any specific antitrust policy, right? So, what it does have the potential to do, I think, if you define competition statically, if you define it as an outcome, the only conduct that can harm competition is conduct that there has to be market power involved. Conduct is only capable of affecting an equilibrium if the firm has enough power to register an impact in the market, right? So that's one big difference.
I see.
And that's a positive. Most people consider that one of the real contributions of the static conception of competition is that we no longer condemn conduct when that's ambiguous. We do it with per se illegal conduct, right? If firms fix prices, they can do that and not have market power, and it's not only illegal, but it's a criminal act, even if there's no possible change in equilibrium outcomes as a result of the conduct. So that's the per se rule is very much a behavioral rule, and the per se rule dates back to the very earliest days of the Sherman Act, before there were any static conceptions of competition. But what adopting a behavioral view of the term allows, it allows for the prospect of antitrust liability without proof of market power. And I think under a static view, you really have to deal with market power in every antitrust case, whether implicitly or explicitly. And so, hopefully, if courts give us a sort of textually faithful reading to that term in the statutes, then we can get to a place where there's more quick look, there's more rules like you see in, for example, activists, where we can get to step 2 of the rule of reason with some behavioral evidence, a large and unjustified reverse payment. That's a sufficient proxy for a threat to competition without defining markets or trying to measure market shares and market power. We have some of that under current law, but it's few and far between. A lot of people say we have really a dichotomous approach in this country now, where it's either rule of reason or full-blown rule of reason, or it's per se rule. The quick look is really shrinking, and I think a lot of people feel, I would count myself among them, that the rule of reason is just a failure because it's so unadministrable, and the deck is sort of stacked against plaintiffs so heavily that I think appreciating competition as a behavioral concept can sort of open the door to more flexible liability standards. And we don't have to let go of market power as sort of the core policy concern for antitrust law. I don't think it's an either or proposition. It's just, it's just a little more flexible.
If behavioral means letting go market definition, this is an argument against my own economic interest, but because a lot of billable hours would be taken away, but and many trees would be spared in economic reports. But my God, if you saw some of my depositions where we have like definitive dispositive evidence that the restraint, say suppressed wages, all we talk about for 7 hours is what's the relevant market. It's just like it's like the defendant's playground. It's like, don't look at the body, that's spewing blood everywhere. We want to talk about this academic exercise about balancing, pins on needles. Anyway, Darren, did you want to jump in with another question on Randy's article?
Yes, I do. So, all right. So I actually teach, I teach stat reg. So, I do some statutory interpretation stuff. So your basic notion, we were talking about what the value of competition is, and you're doing a statutory interpretation exercise, but hasn't Congress already told you what the value of competition is, therefore? Like, namely, protection of small business, protection of democracy, labor, right? Aren't those the indicia that Congress has given you to determine what competition is? So it's not just the word itself, but also the meaning that Congress has given those words. And so it goes back to my notion of these rules of the game, right? And so if you go to legislative history, it talks about, the worry of big business, suppressing wages and things of that sort. So doesn't that help flavor the term?
Well, I think you won't. I'll put on my Antonin Scalia, Brian Garner hat. You certainly don't find any of those goals specified in the language of any of the statutes, right? The statutes talk about protecting competition and preventing trade restraints and monopolization. And again,
then hang on a second, Randy. If you're going to put on your Scalia and Garner hat, I'm going to put on my Breyer hat, and so we'll go through the Breyer patch, and I'll be a purposivist and say you can't define those terms without knowing what the purpose of those terms are. So, in essence, I'm doing a textualist exercise too, but I'm looking at it through the lens of what Congress's purpose was. That helps define the term.
Well, I think again, like you can certainly, and I'm not denying that, concern with protecting small businesses, concern with preventing large concentrations of privately held economic power. This is clearly in the legislative history. It's not in the text, certainly, but what is in the text is concern about competition, and even when the antitrust statutes aren't talking about competition directly, it's using a lot of verbs, right? It's restraining, it's monopolizing, it's merging, and it's conduct that has tendencies, right? Mergers that tend to create a monopoly. So it seems really focused on behavior. The statutes, a lot of use of action words, unfair methods of competition. in the FTC Act. Methods are ways of doing something. They refer to actions typically. So so market structures, I think again, this gets into the rule of reason and what reasonable competition would be if competition were defined as behavior. And I think certainly questions about what market structures are conducive to the behavior that antitrust law seeks to protect are potentially relevant and potentially factor into the reasonableness inquiry. So Darren, I would say, we don't have a lot of the legislative history is indeterminate in many respects. A lot of it is in the eye of the beholder. But this idea that the antitrust laws protect competition is clear. It's in the text. The Supreme Court has said it in numerous cases. If you just eliminate the not competitors part of the famous dicta, it's the antitrust laws protect competition. So that's a well-accepted proposition that I think we should be able to organize around.
All right, let's move on to our third topic, if that's okay, which is the future of AAI. It's the last one. We're rounding home. We're rounding the bases. We're approaching home, I promise. But we're in the spring. It's beautiful outside. The American Bar Association Antitrust Division is hosting its annual spring gathering, and I'm not going this year, and maybe forever, because the American Bar Association issued a formal letter opposing Senator Klobuchar's bill that would have banned self-preferencing by dominant platforms. I think it was aimed at Amazon and Google in particular. And it would do so outside of antitrust. Just thought it was odd for the American Bar Association to weigh in on that thing and to weigh in so strongly. Now, the AAI, by contrast, didn't weigh in, but they were assiduously silent. And that also hurt my feelings, but I'm not protesting the AAI the way that I'm protesting the ABA. But it still hurt my feelings. I feel like some progressives felt like they needed some support there and they didn't get it. And I realize there's a change of the guard now, new management. You're the new president. I'm just curious. I don't want to reopen old wounds, but what's the future? Do you have an idea of what the future is going to hold about how AAI is going to handle bills that would regulate the platforms outside of antitrust? There were two last year, and just in disclosure, I was Salini's witness for the House hearing on the self-preferencing bill, so I had a little bit at stake in there. But why don't you weigh in? What's the latest thinking of AAI on these topics?
Yeah, so it's a fair question. Let me say this, and I won't address any specific position on any specific piece of legislation. So AAI has a staff, and the staff has its views. We also seek feedback. We have a large advisory board of many of the leading antitrust experts in the country. We solicit views of experts, and it's not uncommon that we just can't come to agreement on something. And so we may not either endorse or oppose any given piece of legislation sometimes when that happens. AAI is a big tent organization, right? We have our community includes some very strident anti-monopolists and some post-Chicago progressives and a whole bunch of others with a diverse array of views. So we're not sort of a movement organization, we're a big tent organization. And so we do what we can to help. I think a lot of times, we're also an analytical organization. We're a lot of lawyers and economists and people who are practicing in the field or studying the field academically. And we can sometimes play a very valuable role, and we can contribute behind the scenes. And we've done that, frankly, with a lot of the antitrust legislation. We don't go reaching out to folks, but when folks reach out to us and ask for views, we help, and we try to do what we can. I'll just, and again, so given everything I just said, I don't want to speak for AAI, for the entire community, but I'll speak for myself in saying how I view, legislative efforts that, as you said, I think it's well said, that are sort of operating outside the framework of antitrust law. To me, there is, it's important to not always be a competition maximalist, right? We generally disfavor exemptions from the antitrust laws. And if you look at examples like McCarran-Ferguson or the Shipping Act exemption, a lot of them have just been pretty disastrous, I would argue. Then you've got the labor exemption. You've got exemptions where Congress has made a political choice to set aside competition goals and prioritize other values. The health and safety of workers and raising living standards is a paramount goal. We don't prioritize atomized competition among workers over those values. And that's competition policy, but that's also that's the political side of competition. And I think that democratically elected officials can and should respond to the will of their constituents when they want to prioritize other values above quote unquote competition values. And to me, that's a perfectly legitimate and appropriate exercise and a type of competition policy that's completely defensible.
Right. Can I say one? Oh,
yeah.
Can I just jump in one thing? Because I know Darren is chomping at the bit to ask his question, but can I say one just relatedly? Also, this is my view, but it doesn't have to be yours, although I think it's an excellent view, is that we don't have to solve every competition problem, through the rubric of antitrust. I'm thinking like the Consumer Financial Protection Bureau right now is set to regulate overdraft fees and credit card late fees. Recognize there's a competition problem, which these are aftermarkets, and we can't count on customers even knowing what the damn late fee policy is going to be when they sign up with the account. They kind of find out after they're in deep doo-doo, and so they're putting effectively caps on those fees. It's a way to tackle a competition problem, basically a market failure outside of antitrust. And I'm only asking that sometimes we have to, as excited as we are in the antitrust camp, we have to sometimes let others tackle the problems outside of antitrust. I think that's what that bill was going to do. Sorry for letting me grab the mic, but unless you want to respond, Randy, otherwise Darren can take some more questions.
Yeah, just quickly, you often see criticism from the U.S. directed at other foreign competition authorities that for sort of using so-called non-competition values or sort of muddling their competition law with other social values. And it just, to your point about there are other ways of doing competition policy, we do that here too. We have a bunch of sectoral regulators, communications, energy, elsewhere, where there are public interest determinations that factor in competition alongside other values. We have CFIUS. We factor, we evaluate mergers for national security. Those are part of a competition policy, or they're certainly relevant and related. So, and we're not as pure as we sometimes like to think we are.
Yeah, we're not as pure as some people would like us to be. So every time I talk about like things like consumer welfare, I pose a hypothetical about child labor laws, and if they went away. And so they're like, well, if child labor, that's outside of antitrust laws. If they want to pass a piece of legislation, that's fine. And then if someone tries to pass a piece of legislation such as the type that Hal is talking about, then the antitrust folks go, oh no, that'll mess up competition. We can't do that, right? So there's a little bit of inconsistency, and I think that one of the things that makes that inconsistency accentuated is the consumer welfare standard. And I know the AAI has endorsed, and I'm on the AAI advisory board, I should mention that, has endorsed the consumer welfare standard. Mark Lick, Gabriel Lozada, and I have written lots about how it's flawed and should not be used as the basis for anything. What is your position? I'm not asking you to speak for AAI, but since you are the president, what's your position going forward about either the consumer welfare theory or trading partners or whatever else we want to call this thing as we keep rebranding it, output model, whatever else we might try to rename consumer welfare? What's your position on it?
Well, so I'm going to answer your question. But first, let's get out. So I've read your paper. It's an excellent, fascinating, thought-provoking paper that I spent a lot of time with. And some of it is definitely over my head because the economics are too much for me as a lawyer. But just to get out on the table, what would you say? Let's take the label consumer welfare out of the equation, and let's think about effects on the other side of the market or performance indicators in relation to challenging conduct. Does that have any probative value in your view? Should we look at what happens on the other side of a market when we challenge conduct?
You
Should we
mean
look at output price increases, things that are sort of paramount or the only relevant criteria under a consumer welfare standard? Are they relevant for you?
they're relevant, but they're not the whole story, right? So you could have an output increase, but that doesn't by itself necessarily mean anything about welfare. And we've proven that. So despite the fact that pro market doesn't like the fact we prove that. But so yeah, there's other things on other, it's a two-dimensional graph in Bork's book, and there's things behind it that we every time we should try to focus on it, we go back to this notion of output and perhaps its relationship to welfare. I think it ought to be broader than that. And so that's why I'm always asking the question, consumer welfare, are we going to still stick with this? And
Well, but when Darren besmirches pro market's reputation on our podcast, is that advancing competition or not? I'm
I didn't
sorry.
besmirch this reputation. I besmirched the decision to take down a piece, be that because of
There
what
you go again. There you go, Darren.
Yeah,
Sorry,
I'm
Randy,
going to
go
go put my lawyer hat on, not my economist hat. But seriously, Randy, is that, are you toying with the idea of, I know labor, trading partners, post Chicago stuff kind of gets you to labor, right? But that doesn't get you all the way there. It just gets you to, because at some point the courts are going to go back and go, well, it's really just about output, price.
Yeah. So I'm gonna hide behind my organization a little bit, but also because it's the reality. I'm not gonna come out right now and make a grand pronouncement that AAI is renouncing consumer welfare as a goal for antitrust law. That is an important question, and there's a lot of people I think at AAI who probably have diverse views on that question as well. But I'll give my personal views, which I will say I'm sympathetic with those who criticize consumer welfare as an incredibly misleading label. Jonathan Cantor I've heard him say multiple times, it's a quip, but it's something to the effect of, you ask five people what the consumer welfare standard means, you get 6 different answers, and that's not a standard. I agree with the thrust of that point. And I think what you mentioned in terms of trading partner focus, capturing effects on suppliers, capturing labor market restraints and anti-competitive harm, certainly I think it's pretty uncontroversial, actually, that antitrust law needs to protect against all of that. And I also think there are a lot of cases where output and price just don't explain the court's decision. Microsoft is one of them. Squashing a nascent competitor, there's no way to prove an effect. That becomes pretty close to thinking of competition as behavior, in my view. There's not much in the way of a welfare effect when you do that. You're conjecturing, you're projecting, you're making a lot of assumptions about what that firm could possibly do one day. Invitations to collude are banned under Section 5 of the FTC Act, even when they're definitively rejected, right? Those are a rejected invitation to collude is something that cannot possibly have a welfare effect, whether it applies to a consumer or anyone else. mergers that, theories of harm relating to serial acquisitions in mergers. I think it's a stretch to look at all of these through a welfare lens, and yet we protect against them. We should protect against them. So I think there's a case to be made. I don't know if this is responsive, Darren, or not, but I think there's a case to be made that we do look very broadly already, and that we should.
Well, I'll agree with pretty much everything you said except for one thing. And then I'm gonna let Hal ask his last question. But the one thing I disagree with you with is you said that you could get 1,000 different answers, or I'm paraphrasing. I'm just putting words in your mouth, but about what consumer welfare means. I think that's true in antitrust economics, because everybody wants it to mean whatever they think it means. But in regular economics, in every other area of economics, we always know what we're talking about. Which means that, maybe antitrust economics needs to, maybe read outside of its own little circle for a bit. But that's my soapbox. Hal?
I want to talk about amicus briefs to finish things off. And AAI has a very vigorous program in that dimension. I'll also just mention the Chamber of Commerce filed an amicus brief in the UFC case, the Ninth Circuit, which Ninth Circuit didn't pay attention to that. But your briefs, on the other hand, by contrast, have a lot of impact. Why don't you tell us about one or two that are out there right now, maybe some important cases that are being considered, and where AAI has weighed in, and how you hope the outcomes shape up?
Yeah, well, thank you for saying that about the AAI amicus program. Very, very proud of that. I ran that for a long time, and now our vice president, Kathleen Bradish, runs that program now and does a fantastic job. And just have seen just recently, the Regeneron case in the Second Circuit, very positive decision, sort of following a lot of arguments that we made in our brief, which is really wonderful to see. We were looking closely at the Spirit JetBlue case. No longer have to worry about that as a potential amicus opportunity. So I guess I'm hard pressed at the moment to think of any specific cases where we have briefs coming down the pike for sure, although we're looking at several. Maybe I'll just some areas of the law that that I think we're looking for cases and that we consider a priority. One, I think refusal to deal law has gotten really out of whack. I think there's a real problem with what people sometimes call Trinco creep. Applying really strict refusal to deal standards in context and under fact patterns where sort of Trinco's logic just doesn't apply. I think we've seen a weakening of course of conduct claims in a way that just contradicts some Supreme Court precedent about not sort of compartmentalizing course of conduct claims and evaluating them individually, but instead looking at them holistically and giving plaintiffs the full benefit of their proof. So that's a principle. It's going to be relevant, I think, in a lot of the tech platform cases, but it applies in lots of different cases, and it's an important issue. Amex has always been a hobby horse of mine. I've written a lot about Amex. I think it's an abomination and needs to be stopped. We almost had a chance at that one in Sabre Fairlogics, but we didn't get to the appellate court. But we'll be looking for applications of Amex, expansive applications to two-sided markets that are not simultaneous transaction platform markets like the payment card market in that case. And we'll be looking to limit that holding as best we can, prevent it from doing any more damage. So that's just a small sampling. I could go on. I'm happy to if it'd be helpful. But yeah, and to listeners out there, one of the ways we find amicus opportunities is to have them brought to our attention by enterprising plaintiffs, lawyers, or anyone else who's just paying attention. So always love to hear from people with ideas.
Great. I might take you up on that one after this call. Darren, any final words, or can we let Randy go back to his normal job now?
No, thank you for taking time to talk with us, and also for I know we're kind of hitting you hard today, but you know they made a great choice in selecting you as president. So
Yeah. Well,
Well,
hopefully
thank
we
you
can still be
guys.
friends after.
yeah, and you know, when you said Trinkle Creep, I was thinking something else completely, but now I get it.
Yeah. All right. Well,
Uh,
thanks so much for coming on, Randy.
Thank you guys. Love the slingshot and the sling. Keep up the great work, and thanks for having me.
All right.
Thank you. Take care.
Hang in there.